I will be brief. In terms of the U.S. Trust case, that's simply not my interpretation of the law. I'm not talking about diluting the standard. I'm stating the standard. One does not just look at the plain language of the statute according to the U.S. Supreme Court. As this court said in Burgos, it was the majority's opinion that state contract law controlled whether there was a formation of a contract.
But let me just ask a simple question on U.S. Trust. Was there ever a contention that there was no contract made, such as there is here?
Well, no, here, like,
doesn't that?
No, Justice Patterson, because they are conceding there's a contract. They're claiming the terms are different. They conceded there was a contract in 2006. They conceded there was a contract in 2010 before Judge Perillo in NGA versus State. They're simply saying there's not a contractual obligation regarding COLAs.
Right. Well, so let me ask the question more narrowly. Right. There is a contention. We are here because of a dispute between the parties as to whether there is an intent by the legislature to create a contract as to the term we're talking about, which is the COLAs. In U.S. Trust, was there an analogous dispute as to whether or not there was a legislative intent to create a contract?
No, but the case did provide other rules of law. They're not dicta. That's what one says when you're saying, I don't like the rule of law. It's not applicable.
Not asking about dicta. I'm asking whether the issue that we have,
correct.
The determination.
It wasn't about terms. It was not about terms. They conceded there's a contract, just as the state has conceded partly there's a contract. But the rule of law in those footnotes doesn't dilute the standard. The standard incorporates state laws regarding interpretation and enforcement of contracts.
I understand,
that includes statutory
interpretation. We're talking about a standard here that applies to a particular type of dispute, and that is whether or not there's as part of
absolutely
federal and state contract law, is there a contract?
Correct.
And all I'm asking is, did the U.S. Supreme Court, did a lot of things in U.S. Trust, no question, but did the U.S. Supreme Court have before it the same kind of dispute that we have today, so that its statement in the two footnotes that you're talking about could be interpreted to be a standard that applies today? And I think the answer to that is no, it was a different kind of inquiry in that case.
No, the cases that counsel cited, subsequent cases, the General Motors case and others, use that. In fact, the First Circuit case that Ms. Riley uses for the unmistakable intent doctrine as opposed to clear indication, different words for the same test, Justice Patterson, those rules still apply. When you're talking about specific terms, you still use that same analysis. You have to look at state contract law, rules of construction about how to interpret it. The fact that they had a contract that was conceded doesn't change the operative rule of law from U.S. Trust or those subsequent cases like General Motors. So my point is that it's not just the plain language. The goal, even under subpoena, is what was in the minds of the legislators, as if that was truly possible to figure out. And we have to look at artifacts, not just the plain language of the statute, the legislative history, and other statutes that you have to read together.
What precise footnotes in U.S. Trust are you relying on?
Well, Your Honor, that would be footnote 14 and 17, Your Honor, for the majority. The point I was trying to make, Your Honor, is that I'm not diluting the standard. I acknowledge it, but part of the analysis in reaching the standard is that we have to look to our own state contract law regarding interpretation and analysis, and that includes rules of statutory construction. Otherwise, we would just simply have someone read the statute and not look at anything else. Not the legislative history, the surrounding statutes, the circumstances. All of that is grist for the mill in determining if there was a clear indication to cover it. And I believe it is, for all the reasons that I've mentioned and co-counsel regarding the exception of health benefits, the language, and the entire history of the Pension Adjustment Act that the Appellate Division analyzed. I mean, this was a 60-page opinion, Your Honor. These judges looked at each separate statutory provision and came to the conclusion it was clearly indicated that COLAs included. In fact, COLAs apply to every single pension fund without fail. It could hardly be anything but one of the laws governing the retirement system. Otherwise, it's meaningless. It governs nothing else.
It argues that COLAs are specifically outside the Pension Act, and that if it's in the Act, it's protected. If it's outside the Act, it's not. And that's the distinction.
Right.
Could you respond to that?
Well, first of all, that argument comes very late in the day. It was never made in the Appellate Division. Not today's day, the length of the case.
Oh, okay.
Over the 5 years this case has been ongoing, Your Honor, they never attempted to define this word.
But they did now. So
they did now. And when they finally recognized that they needed to grasp onto something, that could limit what benefits program means because it's so broad. So they chose subsection 1, which in their letter brief before the appellate division, they disavowed. It has nothing to do with the non-forfeitable right. The light bulb goes on. We need to attach it to something that excludes COLAs. Let's choose that section. And my response to that, Your Honors, is twofold, and it was Justice Albin who mentioned it. You have to read the entire statute together. Its benefit program shall not be reduced under the laws governing the retirement system. The Pension Adjustment Act has but one purpose. It truly is that simple, I believe. And that is, it simply keeps pension benefits from being eroded by inflation. If you get a state-administered pension plan, you get a COLA. Everyone does. That's the only purpose. If it's not a law governing the retirement system, what is it?
So that includes things other than the Pension Act itself? Or the
Yes, it's the laws governing the retirement system.
You made a state.
I'm sorry, Your Honor.
Finish up. Finish your answer.
No, I'm sorry. I believe it is all that encompassing. Justice.
You made a statement before that once the COLA is calculated based upon the pension you are receiving, which includes prior COLAs.
Right.
And that once the COLA is calculated, it becomes part of the base benefit.
Correct.
Does it become part of the base benefit before it's calculated?
You mean the expectation, the right to it?
I think Justice Levecki asked that, and I'm asking you.
Right.
You made a statement in your prior argument that it becomes part of the base pension once it's calculated.
It does, and that's when the new calculation is based on the combined.
Hasn't been calculated. You'll get it next year based on last year's cost of living increase. Is it still part of the base pension before it's calculated?
If one is covered by the non-forfeitable right, yes, which is why the legislature probably thought, based on cost in 2010, they were going to repeal that right prospectively going forward. They recognized there was a contractual right to COLAs in both the AG's legal opinion to the state treasurer and another legal opinion that's yet been referenced from the Office of Legislative Services, also came to the conclusion that once a retiree retires, there can be no reduction in pension benefits. And that includes not just what they've received, but what they're entitled to under the law.
Okay. So their current pension can't be reduced, and their future pension can't be reduced either.
Which would be COLAs when you talk about future pension.
I get you.
Right.
That's your argument.
Under the non-forfeitable right to those who have it attached. Yes.
But that's not what the statute says.
No, it says it says the benefits program shall not be reduced, not benefits, Your Honor. The state was very well in sort of diverting the idea that benefits aren't being reduced, that there are these committees that can reinstate them. I'm not even sure those committees are constitutional under the statute. In fact, those committees are actually allowed to reconfigure formulas, Your Honor. Not use of service.
You're not here to challenge their constitution.
No, I'm not. I'm trying to say there are other problems with Chapter 78. And so my point is, Your Honor, that if you have a contractual right to a benefits program, a statutory scheme, you have an expectation of COLAs because it's part of those rights. The state recognized that in 2010 and terminated it for all new active employees as of, I think it's May 20th, 2010. Those people are back in the land, I'll say, of SPINA, of property rights that are not yet defined unless this court chooses to do so in light of the language that was in SPINA, that they trusted the legislature to do its job, which, at least in Burgos, my reading of this court's opinion is that there was a staggering loss of trust in the legislature given how it's funded and dealt with the pension systems. But to those people who are covered by the non-forfeitable right, it's attached, and certainly if you've retired, it's more than attached. You've completed the contractual arrangement. The only thing left for the state is to pay out those lawful benefits. Now, I started initially my rebuttal with those footnotes. I believe they're key. I'm sure Your Honors will read them. I'm not asking for a dilution of the standard. I'm enforcing the actual standard that our U.S. Supreme Court has provided, and it is repeated in the other cases, General Motors and the like. In addition, Your Honors, I would like to also remind the Court that in Burgos, it did hold that pensioners did have a non-forfeitable right to their pension benefits. I understand it wasn't specific as to COLAs, but obviously you've also determined that there is a contractual right. What we're talking about is very finely the definition of benefits program, and that includes not only an analysis of those terms, of the rest of the statute, the other statutes, and the legislative history.
The issue we have today was not raised in Burgos.
Well, the non-forfeitable right came up, and there was language from the majority opinion indicating.
But in terms of COLAs, that was not.
Right, not the COLAs, but essentially the base pension benefits. So that determination's already been made by the court. We're really down to the nitty-gritty of
The
what
base benefit decision's not been made yet. That's what we're here about.
Well, as I read Burgos, it didn't talk about COLAs, but it talked about the base pension benefit, of that they're entitled to their deferred compensation.
It
I
sounds
think
like
the
you're
exact
both.
quote.
Sounds like you're both arguing for and against that Burgos addressed the question that we have in front of us today. I'm not following your position.
This is the language that I'm referring to, and maybe I'm misunderstanding it. We reiterate there is no question that individual members of the public pension systems are entitled to this delayed part of their compensation upon retirement. And it was repeated at, I think, the very first sentence of Burgos. My interpretation of those two sentences was that there was, in fact, a contractual right to one's pension. It may not be COLAs, but that's how I read those two sentences in the Burgos funding opinion. That's what I'm referencing, Chief Justice.
Is there anything else you'd like to rebut?
Lastly, on the issue of equity, which apparently the state has not really addressed, if you reread both the Attorney General's opinion and the Office of Legislative Services opinion, they do too admit that once a pension benefit has been provided and an individual is retired, equity prohibits changing that benefit to the detriment of the pensioners. So as an alternative, I believe that even if you don't find that the non-forfeitable right covers COLAs, I believe it does forcefully, then I believe that equity would cover all the individuals who retired before 2011 under well-established principles of this court and the appellate division. And I can think of nothing else that would be more grossly unfair or manifestly unjust than to deprive people who've worked so many years of their lives to their justly due hard-earned retirement benefits. Thank you, Your Honor.
Thank you, Mr. Ouslander, and thank you to all counsel for the very fine presentations and briefs that were submitted. We'll take the matter under advisement. Court's in recess till 1 o'clock.